First commenter will be the Governor of North Dakota.
Good evening. I am Jack Dalrymple, the Governor of North Dakota. Appreciate the opportunity to comment on the Lake Sakakawea Draft Surplus Water Report and Environmental Assessment released by the U.S. Army Corps of Engineers on December 16, 2010. Stated previously in letters dated June 10, 2010 and October 28, 2010, the state of North Dakota has serious concerns about the Corps' recently introduced restrictions and policies regarding access to water in the Missouri River. It seems that Corps policies are now blocking access to the free flow of the Missouri River, which is rightful property of the state of North Dakota. This is an outrage. In 1957, the Corps completed construction of the Garrison Dam, creating a reservoir that holds more than 24 million acre-feet of water. Today, Lake Sakakawea is the third largest man-made lake in the United States and is unique to all other reservoirs in the United States. The Corps' reason for the sudden implementation of this policy stems from problems that have arisen on East Coast reservoirs due to their smaller size. Unlike the East Coast reservoirs, the storage capacity of the Missouri River main stem reservoirs vastly overshadows any proposed water storage needs within North Dakota by several orders of magnitude. The blanket policy proposed by the Corps is utterly inappropriate for the state of North Dakota. Prior to the enactment of the 2008 Corps real estate policy, water users were able to gain access to water in the Missouri River main stem system through a land easement application process and associated permits without being charged a fee. The draft report states that the Corps has issued 142 water intake easements around Lake Sakakawea, only one of which has a fee-based surplus water supply agreement. These easements were issued over the last 60 years without the need for a reallocation study or a water storage contract. Thus, the Corps' recent change in position of requiring the allocation of storage in reservoirs and issuance of water storage contracts to existing and potential water users under the 1944 Flood Control Act and the Water Supply Act of 1958 is unjustifiable for a number of reasons. First, the Missouri River is a vital water source to the state of North Dakota that existed prior to the construction of the main stem reservoirs. According to Article 11, Section 3 of the North Dakota Constitution, all flowing streams and natural water courses shall forever remain the property of the state for mining, irrigating, and manufacturing purposes. The Missouri River continues to flow through Lake Sakakawea today and cannot be considered stored water due to permanent rights held by the state. North Dakota water users must have access to the river without cost and without the requirement of surplus water supply agreements. Second, the main stem reservoirs were constructed with planned benefits to the states, where land and resources were impacted. Approximately 550,000 acres of prime farmland were taken in North Dakota for the construction of the main stem reservoirs. Congress has since recognized the majorities of these benefits have been realized downstream and has provided amendments to the 1944 Flood Control Act to address some of these inequities. Additionally, Section 301B of the 1958 Water Supply Act provides the recovery of capital costs may extend for a period of up to 50 years. That 50-year time period has expired. The Corps should not have the ability, nor a federal responsibility, to charge water storage costs to repay for the construction costs of the dams for surplus water when original repayment contracts were never required at the start of construction. The Corps' proposal to charge for construction costs is unacceptable. They then exacerbate this ill-conceived idea by basing their fees on what would be the costs to construct the dam today. Third, the draft report only proposes a storage fee for water users in the upper basin states that withdraw water directly from the main stem reservoirs, but does not charge downstream users a similar fee. Yeah. Reservoirs like Lake Sakakawea provide numerous benefits for all users, not just those that withdraw water directly from the reservoirs. Hydropower, navigation, water supply, and flood control are just some of the benefits reaped by downstream water users that are not charged a fee. The Missouri River, including Lake Sakakawea and Lake Oahe, is valuable to the state of North Dakota and is a resource that should be readily available to access without cost. Access to Lake Sakakawea alleviates environmental and infrastructure concerns within the western part of the state and also benefits communities statewide through water projects such as the Red River Valley Water Supply Project, the Northwest Area Water Supply Project, and the Southwest Pipeline Project. Restrictions in access would affect these very projects. The farmers and ranchers that rely on access for irrigation purposes, hinder the development of domestic energy resources, and eliminate the 3 affiliated tribes and the Standing Rock Nation from freely accessing water supply. As development in North Dakota continues, Missouri River water becomes an important component to the growth of the state and the nation. Just as important is the ability to access Missouri River water in a timely manner in order to meet the immediate water supply needs of the people of North Dakota. In summary, I ask you to continue to expedite the work required to process easement requests that are currently before the Corps. Further delay of processing these easements is unacceptable. Using U.S. Army Corps of Engineers easements to block North Dakota's access to its own rightful water supplies is not only an improper use of the intended purpose of these easements, but is also an unconscionable and unjust attempt to achieve monetary gain where none is justified. Financial claims have not been sought in the past and contradict states' rights and congressional authorizations. All considerations for the use of Missouri River water have been settled in the past and should not be open to further discussion. I urge the Corps immediately to continue to provide water access to existing and potential water users without cost.
I'm the Attorney General of North Dakota, and I appreciate the opportunity to be here this evening to provide testimony. North Dakota has been blessed with many natural resources, and the Missouri River is one of the greatest of those natural resources. As a remarkable and grand river, American law, not just North Dakota law, but also the law of the United States, gives the river special legal status and recognizes the state's special interest in it. Consistent with this status, prior to statehood, the United States held the Missouri River in trust for the benefit of the future state of North Dakota. Federal law prohibited the government, except in limited and exceptional circumstances, from holding on to the river or conveying it to other interests or otherwise depriving North Dakota of this asset. The United States Supreme Court has repeatedly recognized that navigable rivers like the Missouri are a fundamental attribute of a state and its sovereignty. It is a principle adopted by the citizens of our state in our state constitution, which declares that flowing streams and natural water courses shall forever remain the property of the state. There is good reason why we here in North Dakota refer to the bed of the Missouri not as public land, but as sovereign land. Before the federal government dammed the Missouri, the river provided the needs of for those who live near it. Our people, the farmers, the ranches, the businesses, along with the wildlife, all relied on it, and all were satisfied, while leaving much water to spare and to send on downstream to our neighbors. Its natural flow, even during the lowest of flow periods, was and continues to be more than plentiful for those needs. Nature's providence is more than enough to continue to meet our needs. Section 3 of Article 11, that has already been referred to, but which I think bears repeating, clearly provides that all flowing streams and natural water courses shall forever remain the property of the state for mining, irrigation, and manufacturing purposes. And this provision in the Constitution was accepted by the United States Congress at the time when it admitted North Dakota into the Union on those terms. River flows that continue through Lake Sakakawea are not and should not be considered stored water, because the state would have been entitled to access to that water even if the Garrison Dam had never been built. While it is not just, nor do I think legal, for you to demand that we get your permission to use water that naturally flows through our state, it borders on insult to demand that we pay for it. And the law, recognizing as it does North Dakota's unique and sovereign interest in the Missouri River, limits the Corps' authority over those natural flows. You are aware, I'm sure, as aware as I am, that changes in the operation of the river system often brings litigation. I will not reiterate the specifics of our legal position. The governor has covered them. Senator Hoeven has covered them as well. I'm not going to reiterate them here tonight, and I know you've been provided with an outline of our legal position previously. But know this, North Dakota sacrificed enormously for the construction of the Garrison Dam. And while the Corps built those dams, it did not put natural flows through the Missouri River Valley. The Corps has some authority to manage the dam, but not the kind of authority that it asserts here. And I'm confident that a court would recognize such limits and the extent to which the proposal that you have in front of us exceed those limits. For the record, there should be no doubt that the state of North Dakota is obligated, and I am, as Attorney General of the state of North Dakota, obligated to do everything that it must to assure its authority over and ownership of the water that belongs to us. We think the course that you are proposing is contrary to law and in violation of federal law, state law, and clearly established Supreme Court jurisprudence. Thank you very much.